If everyone could take their seat, please, we're about to start the hearings. We're about to start the hearings. If I could have your attention, please. Thank you. Today is Thursday, March 5th, 2020. It is 9 o'clock on the nose, as it were. We're here in council chambers for a special hearing examiner hearing. Calling the hearing to order at this time. Before I ask the clerk to announce the case, I do want to make some preliminary comments. Our process that we follow here in Cape Coral is a little bit different than the process followed in other jurisdictions. In our process, the clerk reads the introduction of the case and then she swears in anyone who is testifying. City staff then testifies as to compliance with the public notice requirements, and assuming the public notice requirements are met, then the applicant will go first. The applicant is required to present an entire case. What that means is that all elements of the application request process under the applicable City of Cape Coral regs must be addressed. If that is not the case, then the presentation is deficient and the other consequences flow from that. City staff goes second. City staff will present their case. Public comment is next. All public comment must be under oath. We do not accept any comments made from your seat, and we do not accept any comments that are not under oath. Please turn off or silence your cell phones. Take any cell phones conversations outside the room if possible. If you wish to have private conversations, please do move away from the speaker's lectern so we do not accidentally record your conversation. Any conversation that is recorded, whether it's accidental or otherwise, immediately becomes part of the public record. So if you are going to have a cell phone conversation, please be aware of the fact that to the extent the microphones pick up your comments, they are free for anyone in the public to listen to. As I've already mentioned, please come to the microphone if you have testimony so we can properly record it. And anyone who provides testimony other than the applicant or the staff members is requested to fill out a public participation card so we can properly spell your name. If you wish a copy of the hearing examiner recommendation or order, as the case may be, please provide your email contact information for that purpose. But once again, please be aware that if you do so, your email becomes part of the public record with the City of Cape Coral. Following public comment, once it is closed, it will not be reopened. So if you are here to provide public comment, please make your comments comprehensive, because we do not accept public comment after that section of the hearing is over. Following the closure of public comment, the applicant responds to questions and has the ability to make any final comments, and then staff does the same. And then the hearing at that point is concluded. With those preliminary comments, I am now going to ask the clerk to please announce the first case. Thank you.
Case PDP 20-0001, the address 845, 851, 859, and 877 Cape Coral Parkway East. The applicant, Downtown Village Square, LLC. Downtown Village Square II, LLC, Red Rock Land Corporation. The applicant requests to amend the Downtown Village Square project approved by Ordinance 42-10 and amended by Ordinance 33-19 to modify the phasing schedule and the conditions of approval. Anybody giving testimony today, if you're able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth? I do. Thank you.
Thank you, Madam Clerk. Good morning, Mr. Struve.
Good morning, Madam Hearing Examiner. For the record, Mike Struve, Planning Team Coordinator with the Planning Division. This case was advertised, and those advertising efforts included placing an ad in the news press 10 days in advance of this hearing, mailing to all surrounding property owners within 500 feet of the site or the subject block, as well as posting signs along all 4 streets of the subject block.
Thank you. I will find that proper notice has been given for this hearing, and I did observe the sign on one of the signs on my site visit. Thank you.
Thank you.
Okay, may we have the applicant up, please? Thank you.
Good morning, Madam Hearing Examiner Annette Barbacha, President of A&B Planning Consultants, Inc. I'm here on behalf of the applicants to Downtown Village Square. As Mr. Struve noted, this is PDP 20-0001, and this is a proposed amendment to that application. The owners that have been part of the application historically and also as part of this amendment are Downtown Village Square LLC, Downtown Village Square 2 LLC, and Red Rock Land Corporation. They are the owners of the entire block. I am their representative. This shows the project area, which is unchanged. It's just slightly under 4 acres. It's surrounded by Southeast 47th to the north, Cape Coral Parkway east to the south, Southeast 9th Place to the east, and Southeast 8th Court to the west. What this aerial does not show is demolition that has occurred since the end of December 31st, 2019. The 2 buildings have been demolished. The building at 877 Cape Coral Parkway, which was the former car wash building, and the other is 859 Cape Coral Parkway East, which was the former Fifth Third Bank building. The project as a whole is unchanged. It is still 152 multifamily units, 251,546 square feet of commercial development, an internal public square, a 6-story parking garage with 930 spaces, and a commitment to provide 2,000 square feet of police substation and 2,000 square feet of city office space to the city, and a commitment for affordable housing for 125,000. And we do have an agreement with the city on that. Specifically, we thought we'd just highlight the specifics of the request. It's largely a phasing change that's being proposed. Building B instead of Building A would become Phase 1 of the development, and they would assume all the timing requirements previously required of Building A. Building D, the parking garage, would continue as Phase 2 of the development. The existing tenants in the retail building at 851 Cape Coral Parkway would remain in place. The end of their lease term is November 30th, 2020. The existing retail building at 851 Cape Coral Parkway would be used as a sales center in the future for the leasing of Building B until Building D is complete. The owner of the ice cream shop is here today. We were just talking, and it's my understanding with the principals that he would be welcome in new Building B when it is complete. Building A would become Phase 3 of the project. The other requests we made, and this was just our idea to help simplify the process. We understand sometimes it's difficult to complete reviews in a timely way, and we just wanted to afford the DC director the opportunity to have like a 30-day leeway in the event that they felt they couldn't complete their review timely to enable the applicant to meet all their timeframes. Sometimes there's third parties, like the utility companies, that are outside the control of the city or the applicant. Based on my discussion with staff, they feel that they don't need that. It's unnecessary, but it was part of our proposal. We also understand with respect to the appeal process, the city feels that we already have an appeal process in the event that the timeframes aren't met, but that was also part of our letter of intent.
Are you withdrawing those at this time, or are you moving forward with those requests at this time?
We'll move forward with those requests, but we understand, I'm just conveying the conversation we had with the city, but it is part of our request. We think it's prudent. There is no request to eliminate the proposed fountain, and I just went over the length. This is in location where the Building A is going, so the fountain would be built at the time that Building A is built. And what we had provided was just eliminating it from the first phase. For clarity purposes, the city staff has put it in the ordinance so that it's clear that it will be part of Building A, and we are in agreement with that.
And just for clarity, it is a proposed ordinance, correct? It's not the ordinance. When you say they put it in the ordinance, you're talking about
Correct, it is the proposed ordinance.
Right.
Thank you for that clarification.
Thank you.
This is a chart that the city put together, city staff, and it does reflect the timing changes that are being proposed. So instead of building A going first, it would be building B, and we would, the applicant would submit plans by March 31st, 2020 for building A in its entirety. They would begin construction July 1st, and they would receive a C of O by June 30th, 2021. Building D would retain, which is the parking garage, would retain the same time frames as it had previously, which was, submitting the plans by March 31st, 2021, getting in the ground August 1st, 2021, and receiving a C of O by July 31st, 2022. Building A, we did not put a time frame for, and we told staff that we were open if they wanted to suggest a time frame. It just will be phase 3 for the applicant. This gives you a horizontal view of where the buildings are located. As you can see, Building A is located in the southwest corner. That's roughly a 79,000 square foot building, proposed to be 77 feet in height. The first floor would be retail, the rest would be office. Building B is approximately 62,000 square feet. It would be 70 feet in height, and it's roughly about 45,000 square feet of commercial, 10 units, which would comprise the rest of the building. And then Building D is the garage. This is a vertical look at the buildings. As you can see, this was done a number of years ago, back in 2010, had a Mediterranean look. Building A is shown to the left, Building B is in the middle, and the two residential towers, about 8 stories, are sitting on top of a 6-story building, comprising about 14 stories, excuse me. Building C is also a 6-story building, and Building E in the rear is a 7-story building. This is the breakdown, and just to be clear about this square footage, it is gross square footage rather than just square footage under air. It's the total building. So Building A, the mix of this is 7,492 square feet of retail on the first floor, and 72,375 square feet on floors 2 through 6. There's no residential units proposed in that building, and originally when that was conceived, it was to house Fifth Third Bank, who was going to move their operations from the building that was at 859 Cape Coral Parkway to that building. So Building A had to be first to kind of accommodate them. Building B is more of a mixed-use building. 21,571 square feet of retail is proposed. 10,345 square feet of restaurant is proposed. And the theater space is approximately 13,352. So collectively, for commercial, it's 45,268 square feet. Then the 10 units would sit on top of that commercial bulk. Building C, again, we're not making any changes to the other buildings, but you can see in this chart the square footages of each of the other buildings. Those are unchanged. There is building plans that are being worked at in progress. There's an architect, Rick Miner, also Jason White from Exceptional Engineering are working on the plans and plan to have this submitted prior to the end of March 31st. The applicant had to, in good faith, start preparing something. As we mentioned, the issue that we had, or the applicant had, was that there's a tenant in 851, and their lease goes until the end of November 30th, 2020. So we had reached out to the city back around Thanksgiving time to see if we could get this amendment in progress. And at the time, the city was wrestling with the new zoning that they had put in place, because PDPs are no longer part of the new zoning. It would be a planned unit development. So it took a bit of time for the city to sort that out with the attorney's office to determine what would be appropriate. And based on that, we went forward with an amendment, which is what we have before you today. What they tried to do with this building is they kept to the elevations that were submitted many years ago. They tried to lighten up the color to give it a more modern appearance. The possibility of the interested tenants, and we mentioned to the ice cream shop that they would be welcome in Building B. Nevermind, Cork Soakers are two prominent restaurants in the downtown, and have expressed interest in going in that building. Also an insurance company and some other retail shops. So we feel there's like a pretty good demand for Building B. Not to be repetitive, but the genesis of the phasing was we had to accommodate Fifth Third Bank because they were sitting in the middle of the property. We couldn't demolish their building until there was an office building provided, which was Building A. They have downsized based on a whole host of reasons, so they're no longer present in that location. The biggest concern that we always thought the city had historically was that they wanted Building D, that parking garage, because there was a commitment of 127 public spaces. There's a big demand for parking in the downtown. And we just continue to reiterate to do that garage, since it's not income generating, it really needs 95% of the eligible TIF to make it happen. When Vicki Bateman was part of the city, she reviewed all of this last year with the applicant to make sure that they had sufficient money to do the first phase, but she also reiterated that 95% of the eligible TIF would be necessary to do the whole project. This is just a summary of some of the benefits of the project. You know, the public spaces, 127 dedicated spaces that would be free to the public for 20 years. Maintenance of that space, and again, the square footage for the police substation and the city office space, and the contribution to the affordable housing program of $125,000. They had an economist do an estimate of the jobs of the whole project, which was 1,331 direct and indirect jobs, and roughly 62.9 million in output and 25.4 million in wages. They've complied with the Ordinance 3319, which was adopted last year. They demolished the former Fifth Third Bank and the car wash by the end of December 31st, 2019. And they've also fenced the perimeter of the property. And this was a courtesy of Mike Struve. I thought these photographs really showed it well. This was the kind of before and after shot of the car wash building site, what it looked like in May of 2019 and what it looks like today. This is the former bank building. As you can see, it's been demolished. It's no longer there. And this is looking at the site, looking northwest. And as you can see there, the ice cream shop at 851 is to the left. And there's another shot of the ice cream shop. And everyone felt that that they didn't want to disrupt the business there. They have a lease until November 30th, 2020. It's an active business. You'd see people enjoying it. Just in response to some of the comments I saw in the staff report and presentation, the notion was that it's better if the site is clean. And certainly that's true, but it never was historically, since Fifth Third Bank would have been there in operation when it was originally approved. The timing for Phase 3 was previously not spelled out. They would consider that if that was a sticking point for the city. They would like to allow the ice cream shop to continue its operations at 851, and they would welcome them as a tenant in Building B if they're interested in locating there. We're not eliminating the fountain, as we just discussed. It will be built with Building A. We're just concerned that, that the PDP is not put at risk if the review is not met in a timely manner by the city, because it's out of the applicant's control. And as we mentioned, the private monies were shown to Vicki Bateman previously, that they had sufficient monies to go ahead with the first phase. There are no existing burrowing owls, gopher tortoises on site due to improved conditions, and we've gone back and forth with the city on that. Landscaping and screening will continue to be maintained as the project is developed. The project is consistent with both the city's comprehensive plan and the South Cape redevelopment plan. There's no financial responsibility other than that was noted. The project will be built as approved in 2010 and through subsequent approved revisions, including this proposed amendment. There is no minimum parcel size. Time frames are established in the prior development orders, and then also what we are proposing here in terms of the phasing change. All three owners have executed the applications. We're not seeking any special exceptions except for those, except for any deviations that were approved originally, but no special exceptions. Utilities will be underground. We're consistent with policy 3.15, creation of plazas. Project includes interior plaza and pedestrian connections throughout into the central plaza. We're consistent with policy 3.1.7, structured parking, because of the commitment to the parking garage. We're consistent with policy 3.21, which deals with assemblage. 5 parcels were assembled to create the development site. We're consistent with policy 3.26, incentives for mixed-use buildings with attractive pedestrian-oriented streets. We have that pedestrian plaza in the center portion of the project. And we're consistent with 3.41, creation of, parks, plazas, Central East Plaza throughout the site, and also the fountains and some of the pavers that will be put around the project. What I'd like to do, I did get a question regarding the TIF and also the assessments of the change of the building from a TIF perspective, so I'd like to present that.
Was this presented before today? I don't believe I received this before today.
No, well, I just received a question from Mike this week.
I can't accept documents or
Okay.
documents from the applicant that were not provided in accordance with the deadline. So,
Okay, because my understanding was the question came after you received the information, so I thought maybe you wanted a response and answer to your question, but.
well, you can verbally
Okay.
present information, but I can't accept any documentation type stuff. Thank you.
Okay, fair enough. I just want to look down at this one side. What I did was I looked at, Building A is largely an office building. Building B is more of a retail restaurant building with some residential on the top. And when I went into CoStar to look at, over the last year, what were the top office lease rates in the city, top 5, and what were the top 5 retail lease rates in the city. And those are the numbers that I'm presenting. Building A has 7,492 square feet of retail, and the rate that was shown in CoStar for retail was $30.88. That was the highest rate, the top 5 rates, when you average them together. And that would generate an income of about $231,353. For office space, when I took the 5 top lease rates that went into effect over the past year, it was $18.67 for office buildings. So when you multiply that by the square footage of the office space, it gives you 1.351 million and change. So collectively, the expected income, assuming Class A space, would be in the neighborhood of 1.5 million, 1.582,594. Building B is approximately 62,000 square feet of gross space. When you multiply the retail by $30.88, you get an annual income of $1,397,876. The residential income, we used the comparable in Cape Harbor and some other units that will be of comparable size that are relatively new. And we projected a income of $2,000 a month for those units, which gives you $240. So when you compare the two, the 1.582 million, 594, and the 1,637,876, from an income perspective, the buildings are very similar. These numbers are not absolute because, they will vary somewhat, but From an income perspective, which is how commercial real estate is looked at, it's not just looked at as the total square footage of a building, but what income is derived from it. So what we wanted to present is that there's going to be a big financial benefit from Building B as well as Building A. They're viewed in a comparable way because office space commands less per square foot than does retail. And I stand by for any questions, and I would like to reserve the option to get up and respond.
Thank you. And I do have a question.
Sure.
What specifically is the ground for this request?
The ground for the request, as I understand it from the applicant, is that the lease that is between Red Rock and the Sidecar Ice Cream Shop goes to November 30th, 2020. And my understanding from the Downtown Village Square owners is that they were unaware of that lease term when they negotiated the extension last year. And that's why they came back in November to say, look, you know, we don't want to disrupt this business. They have a term ending till November, and legally they can't, you know. So that's the genesis of it.
And when was that lease entered into?
In October 2018.
Okay, thank you very much.
You
I have
got
no
it.
other questions at this time. Thank you. Good morning again, Mr. Struve.
Good morning again, Madam Hearing Examiner. For the record, Mike Struve, Planning Team Coordinator with the Planning Division. And for the purposes of this hearing this morning, I am requesting to be recognized as an expert in land use planning based on my credentials on file with the City Clerk's Office, as well as my past testimony before you on similar matters.
I will recognize you as an expert based upon your testimony in prior hearing examiner hearings regarding issues similar to the ones that are under discussion today, and also based upon your CV, which is on record with the Clerk's Office. Thank you.
Thank you. This case involves an amendment to an existing PDP or Planned Development Project, which is entitled Downtown Village Square. Ms. Barbacha did a good job of going over a lot of the preliminary information, so I'm still going to cover that, but maybe move forward or through that a little bit more quickly than normal. There are 3 property owners involved in this particular application. All 3 have signed applications that are part of your backup material. All 3 owners are represented by Annette Barbacha of A&B Planning Consultants. The Downtown Village Square is a mixed-use project. It consists of property within Block 62A and the community redevelopment area, the heart of the CRA. Area of the site is around 3.9 acres. This is a aerial, a rather dated aerial, if you will, showing the site of the Downtown Village Square project. This project consists of multiple parcels, and this aerial is probably close to a year old now. And as Ms. Barbacha mentioned, a couple of these buildings have been demolished. The building on the west side of the, or the most westernmost building was the old Fifth Third Bank building, and then the building that's been demolished on the east side of the block previously supported a car wash establishment. There is one building that remains on the site, a smaller 1,500 square foot commercial building. This is a zoning map showing the subject block, and all surrounding properties, at least within 500 feet of the site, have the South Cape Downtown zoning district associated with them. When the project was approved back in 2010, the site had the Downtown Core zoning district, and so the project, because it was approved at that time and has been extended a number of times since, still has entitlements associated with the Downtown Core zoning district. As I mentioned, this project was originally approved in 2010. It's been extended several times, either through the state of Florida or by the City Council. At build-out, the project has been approved for over 251,000 square feet of non-residential uses and a maximum of 152 dwelling units. The applicant is requesting a couple of changes that we've broadly categorized here on this slide. One, they're seeking amendments to the current phasing schedule, or at least the phasing schedule that was most recently adopted by the City Council as part of Ordinance 3319. And they're also seeking to amend conditions of approval that also appear in Ordinance 3319. This is a site plan, again, dating back to 2010, just to show you the general layout of the 5 buildings on the site. You'll notice that the buildings are more or less sequentially identified, moving from the west side of the site to the east. All of the buildings on the site are mixed-use buildings except for Building A, meaning that these other 4 buildings would have both a non-residential or commercial component as well as a residential component. Building D, which is the long rectangular building on the north side of the site, is the location of the parking garage. And on top of the parking garage at build-out, there would be 2 large residential towers that Ms. Barbacha had also alluded to. You've already seen this rendering, but this just shows the relative location of the 5 buildings on this site and gives you sort of a flavor of the architectural style that we expect these buildings would be constructed to. There have been a couple of positive changes associated with the site that have occurred within the last several months. 2 of the 3 buildings have been demolished. This shows the bank building, a before and after view, showing that this site now has been cleared and is ready for development. And then likewise, on the eastern side of the block, the car wash establishment has also been demolished, and that site has now been prepared for development as well. Wanted to go over consistency with the South Cape Downtown CRA Plan. Staff finds that this project is consistent with several policies that appear in that plan, which includes policy 3.1.5, which encourages plazas and open space networks in the CRA, and this project would have a central plaza that runs east and west along the length of the block, which would certainly comply with this particular policy. Policy 3.1.7 encourages structured parking as a way to optimize green space on a site and to allow for parking in the area of the city, which is in many cases deficient of parking. This particular project would includes a parking garage, which complies with that policy. Policy 3.2.1 encourages assembly of property. There were multiple parcels that were assembled as part of this site that constitute Block 62A, so the project is consistent with that policy. Policies 3.2.6 and 3.2.7 or 3.27 encourages the revitalization or redevelopment of properties in the CRA as high-quality mixed-use projects, and that Village Square certainly would, in our view, comply with this policy, given the not only amount of commercial space associated with the project at build-out, but also the fact that it has a pretty strong residential component to it. And then policy 3.4.1 encourages pocket parks and plazas for redevelopment projects. This project does not have a pocket park per se, but it does have certainly a central plaza that provides a place for public assembly and also promotes pedestrian mobility within the project. The project is also consistent with a number of policies in the comprehensive plan. It's consistent with the goal of the housing element, which is to provide good quality housing, offering a broad choice of options. And in this case, the project at build-out would provide 152 dwelling units. City has a documented need for, in particular, multifamily housing, so it fits that or complies with that goal. Under the future land use element, policy 1.9 states the city will not issue a development order or permit, which would result in basically a diminution of the level of service standards. Above those level of service standards that are established in the comprehensive plan, and this project was found to be concurrent with city services when it was approved back in 2010. Policy 1.13 says the city shall discourage new strip development. This site consists of entire blocks, so it has not only a good bit of length, but a good bit of depth too, in terms of the dimensions of the site. Policy 1.15.1, which pertains to the downtown mixed future land use classification. This future land use classification, when the project was approved, allowed a maximum density of 40 dwelling units per acre and an FAR of 4. And the applicant had requested enhanced density through the redevelopment incentive program to allow 39 dwelling units per acre. Now, subsequently to 2010, the city has changed its comp plan. We do now allow for considerably more density in the South Cape zoning district and in the downtown mixed future land use classification up to 125 dwelling units per acre. Policy 4.1 states that future development requiring centralized utilities shall be in the infill or transition area. This is in the infill area. 5.3 states that the new commercial projects are required to meet standards for adequate facilities, and this project was found to be concurrent with city services when approved in 2010. 5.5 encourages the vacation of rights-of-way to facilitate land assembly to allow for a more cohesive and larger development. And this site did include a platted alley that was vacated as part of Ordinance 4210 that approved this project. Policy 5.6 states that services considered to serve new commercial and mixed-use development should include fire, police, and emergency medical protection. The developer has agreed to, and this is codified in Ordinance 4210, to provide a maximum of 4,000 square feet in the liner building associated with the parking garage to provide for a police substation. That would be a maximum of 2,000 feet, with an additional 2,000 feet for some type of governmental service should the city choose to utilize that space. So it's compliant with that policy. Policy 7.3, the city shall provide incentives to owners for assembling land. The fact that the developer assembled multiple parcels was used as the basis in part for the city approving the redevelopment incentive plan to allow for enhanced density for this project. 8.3 states that commercial development shall be designed to minimize negative impacts on surrounding residential uses. We believe this has been met in part by the developer providing structured parking on the site, which is deficient in the CRA. The project also includes open space, not in terms of providing green open space, but again, in terms of providing a central plaza between the buildings. Policy 13.3 states that to encourage housing, employment service, and shopping in a compact area, mixed-use development shall be allowed in the CRA. Again, the downtown Village Square has both a residential and a strong commercial component. And then there are 3 policies that involve the downtown transportation concurrency exception area in which the project is located. And the developer, to comply with this, has elected to implement 5 transportation improvement projects that are all outlined or specified in Ordinance 4210 that will support mobility enhancement in this part of the city. Under the transportation element, there's 2 policies, again, that speak to the transportation concurrency exception area. Policy 2.1.5 requires new development to incorporate design elements to accommodate bicyclists and pedestrians. There's nothing that really would associate with the project that would necessarily accommodate bicyclists, but again, the walkways or the Central Plaza would certainly promote pedestrian movement within the site, and the developer will also be making some streetscape improvements around the periphery of the site, not along 47th as that's been done, but along the other 3 streets that will provide for pedestrian mobility next to but outside the project. And then policy 2.2.6 to promote bicycling, walking, and other forms of transportation. The city shall provide incentives for mixed-use projects. The developer, in this case, going back to 2010, received a density bonus under the redevelopment incentive program by incorporating a number of different elements to this project that included superior to site design, assembling property, providing for a interior plaza, some of the things I've already covered. Project is also consistent with the general standards that the city has established for PDPs. Environmental control standards. Project doesn't involve any new development per se, but when it does, the developer will need to provide the city with a burrowing owl, gopher tortoise affidavit indicating whether or not those protected species are on the site. In terms of maintenance of improvements, Ordinance 4210 required all landscaping on the site to be maintained in good shape in perpetuity. The project is consistent with several policies in the city's comprehensive plan, as I've discussed. In terms of financial responsibility, the standard is not really applicable, as the owner is not being required to bond for any improvements like roadways or that type of thing that you might often associate with a new subdivision. In terms of dimensional requirements, except for those deviations that were approved back in 2010, the project will comply with all applicable regulations. In terms of maximum density, the density was approved for 39 dwelling units per acre, and that was an enhanced or a density bonus that was allowed under the redevelopment incentive program. G, there is no minimum parcel size in this particular instance. In terms of time limitation, there are several milestones with required dates of approval that appeared in Ordinance 3319. This amendment proposes to alter or change at least one of those milestones for one building. Under I, ownership requirements, 3 owners are involved. All 3 have filed applications with the city. Project does not involve a special exception use, so that's not applicable. There were multiple deviations that were granted back in 2010, but there have been no deviations that have been applied for or awarded since then. The project will be serviced with new utilities as a requirement of the city's regulations. Sort of moving on now more to the requests before you this morning. Again, the purpose of this particular amendment is to amend the phasing schedule and to amend conditions of approval. This particular amendment does not change any of the entitlements for the project. The applicant is not seeking any more commercial intensity or residential density than previously approved, does not add any new land area to the project, and does not propose to make any revisions or changes to the site plan that was approved in 2010. So looking at sort of these requests sequentially, the applicant is requested to construct Building B first in place of Building A. We've shown that the locations of these two buildings here. Building A is located at the southwest corner of the site. And the reason that the applicant has provided for this change is this will allow the leasing of the building, existing building at 851, which is not shown here on the schematic, to be honored until the end of the tenant's lease, which is November 30th. There are currently key dates identified in Ordinance 3319 for Building A that include when building plans would need to be submitted to the city, when substantial construction would need to occur, and when a certificate of completion would need to be received from the city by the developer for Building A. All of those dates the applicant basically is proposing would be transferred over now, if you will, to Building B. In terms of our analysis of this, the construction, moving the construction from A to B means that the construction would now begin more in the middle of the block instead of the southwest corner. Generally, and this is something that the applicant, the developer, could potentially work around, but generally it's preferable to begin at one end of the site and to proceed systematically across. It allows for a more predictable, orderly arrangement of development. The applicant has also requested delaying the demolition of the building at 851 Cape Coral Parkway East. Picture of the building is shown here. Ms. Barbacha also showed similar pictures and discussed this with you earlier. Again, the developer wishes to honor an existing lease that expires at the end of November for the tenants in this building. And then at that point, the applicant is requesting that the building be used as a temporary sales center for the leasing of space in Building B once that has been constructed. In terms of our analysis of this request, a sales center is a permitted use in the Southgate District. The building is currently scheduled to be demolished by April 30th, 2020. The new demolition date proposed by the applicant is August 30th, 2022, which is a little over 2 years from the current date that the building is scheduled to be eliminated. Ms. Barbacha had mentioned that in the original order, there wasn't a clear date certain in terms of when buildings were to be removed from the site or when buildings were to be removed or for that matter, were to be constructed. And that's true. However, that changed about a year ago when the applicant came in to amend the project. And prior to the eventual adoption of Ordinance 3319, the city sat down with the developer at that time and identified several key dates in which the city wanted to see the buildings removed from the site. And in addition to that, identified several key dates associated with when building plans and when construction would occur, at least on 3 buildings. That agreement that the city had with the developer was first codified in a term sheet, and that was, there was a date on that associated with March. That was back in March 2019, and that term sheet, by and large, formed the basis for the phasing schedule that was amended that then appeared in Ordinance 3319, and some of the conditions of approval that also appeared in Ordinance 3319. So while the city did not express necessarily an interest as to when certain buildings were to be demolished or when certain buildings were to be constructed in 2010, more recently the city has expressed a very clear interest and desire in terms of when certain things were to occur, in part because of the time that's elapsed between when the project was approved and where we were here just a year ago. The city would prefer a clean site now as opposed to later. It would show to us that the site is ready for new construction activity. It's also a lot, and I'm going to make a generalization here, it's easier to conduct construction activities if you have less impediments on the site, if you have to work around buildings. Now, that's not necessarily a city issue, that's a developer issue. But for example, in the South Cape, this property, like many of the properties in the South Cape, is in an AE7 flood zone. That means all new construction down there will have to be built to a foot above base flood elevation. It will need to be elevated, or the applicant will need to flood-proof buildings. If they choose to elevate those buildings a foot above that current elevation, they're going to need to bring a lot of fill on the site. That's going to be a lot easier to accomplish if all those buildings have been removed from the site at the onset, rather than trying to build those sites up, leave that existing building on the site, and then work around that site again to construct the parking garage. So that's one reason why the city was pretty firm on wanting all three buildings removed in a very short time period before construction began. Under this particular proposal by the applicant, for about 14 months, the sales center and Building B could conceivably coexist. It's also somewhat unclear to us what effect an older building might have on leasing space in Building B. It may have no effect, but it also may be somewhat of a detriment to people in terms of enticing tenants to lease space if they're looking at an older building that is considerably smaller and perhaps outdated and certainly has a different architectural style than the one that they want to lease space into next door. The applicant is also requesting to delay construction on Building A. Construction would be shifted now from July 1st, 2020 in Phase 1, which is identified in Ordinance 3319, to an unidentified date in Phase 3. And this lack of specificity does add to the uncertainty regarding the completion of the project. Again, Building A was supposed to be constructed first out of the gate under Ordinance 3319. Now it is being delayed, but not just being delayed, but to a date uncertain. We had misread or misunderstood a change to the order that was requested by the applicant concerning a fountain at the southwest corner of the site. It was, the applicant had proposed to eliminate this language in terms of requiring the fountain to be constructed during Phase 1. We did not see where it was proposed to be added in later, so we had assumed that that just meant that there was no interest in either constructing that fountain or that the developer didn't want to construct the fountain. As Ms. Barbacha mentioned, that is not the case. What that resulted in, though, is that the construction of that fountain now does not appear in the current draft ordinance before you. I had talked to Ms. Barbacha very briefly before the meeting today. We are proposing that we explicitly state that the fountain would be constructed in phase 3 of the project, basically to coincide with the construction of Building A. And I do have some draft language that I can share with you after my presentation. I've already given a copy of the draft language to Ms. Barbacha as well. Another change the developer had requested was placing language in the development order that would authorize the DCD director to extend deadlines that were codified in the development order by up to a maximum of 30 days. And the DCD director would be given discretion to whether or not such leniency was warranted, or didn't see any provision that would require necessarily just cause, but again, that would be entirely up to the director. The city doesn't support that request. We treat hard dates that are identified in the development order, whether they are in the phasing schedule or they appear in the conditions of approval, as dates that cannot be altered except through a PDP amendment. So that's really the reason we are not supporting this particular request, not that we don't support giving developers and even our directors as much flexibility as we think our codes would allow generally. The applicant has also requested that the developer be allowed to petition council if a timely review of plans has not occurred. It's the city's position that this language is not really necessary, and the reasons for that is because we already do have an appeal process that's in place, and that's in section 3.1.14 of the Land Development Code, so we don't think that we need a second and somewhat differing appeal process just for this particular project. Sort of to summarize some of our main points here this morning, some of the development requests are at odds with city practices, or perhaps even in conflict with our Land Development Code. For example, having a separate appeal process, allowing the director to, at his discretion, to alter dates that appear as a condition of approval in the development order. That's why we don't support those requests. We do think that several of the applicants' requests in terms of delaying the demolition of the building at 851, delaying construction of Building A, does add a certain amount of uncertainty to the project moving forward. It's hard to quantify that, and that's why it's very difficult in some cases to try to actually ascertain what that means to the city. We felt that the construction schedule that was outlined in 3319 was workable. We thought it provided more certainty. Now there is less certainty associated with the project. It was the city's position going back certainly a year ago that the city wanted to have a clean site, a site that was shovel-ready for development, a site that was unencumbered with any buildings on the site, to remove any impediments or obstacles for new construction. We feel that this amendment is contrary to that goal or objective. The added uncertainty in the city's view also adds an undefined amount of risk to the project as well. And normally, while the city wants all developments and businesses to flourish in the city, normally we are willing to allow the market to sort of sort out the risk factor. Sometimes businesses and developments do well, and that's great. And unfortunately, sometimes projects stall or fail. And that's, in our views, just sort of the market working its way through the community and deciding who the winners and the losers are. The reason why this is a big deal to the city in this case is because the city is really a partner with the developer in this particular project. The city has sold the developer some property where the parking garage will be located. The city has made streetscape improvements for the developer along 47th Terrace. The city, under Ordinance 4210, if the project were to completely build out, would be required to pay the developer between $2.2 and $2.8, nearly $2.9 million in permit and impact fees that the city has decided to undertake. So the city has a very vested interest in that, and anything that interjects uncertainty or heightens the risk associated with the project is something that the city is very concerned about. And
Is
so
that a reimbursement, or is that an upfront cost of the permit and impact fees for the city?
the impact fees would be paid by the city when building permits are pulled for each building.
Right,
So that would be the maximum, that estimate is the maximum amount should building permits be filed for all 5 buildings. If it was for one building, naturally, it wouldn't achieve that level of magnitude.
Thank you.
We're also a little concerned that if construction were to begin and then the project was not completed, it is a little unclear how this might affect future development in the South Cape. This is in a very visible site. It's in the heart of the CRA. The CRA, in our view, has rebounded nicely since the recession in 2008, 2009. We are concerned that if this project does not proceed forward, or if it proceeds forward and stalls, that could have some type of debilitating effect on development and redevelopment activities in that part of the city. And it's for those reasons that staff is recommending denial of the requested PDP amendment. I do want to emphasize that we support the project. We support those timelines and those conditions that appear in Ordinance 3319, but we do not support several of the applicants' requests, as I've discussed with you this morning. We have received one phone call concerning this project. It was from an individual just wanting more information about the project. I believe it was a business owner located north of the site. And I'll stand by in case you have questions.
Your staff report references an issue regarding, or potential issue regarding the city right-of-way work being, the proposed modification to the project schedule affecting the city right-of-way in some fashion. Could you go into that a little bit?
I think the concern that we have there is, again, this idea that the city would prefer development to occur sequentially and orderly across the entire site. So if you are beginning construction at one end of a site, not only are you constructing the building at that end of the block, but you're constructing your access, you're making your right-of-way improvements along that side of the building, and then once that is done, you're moving on sequentially, in this case, eastward to the next building. Things happen a little bit more in an unordered fashion if you are beginning in the middle of the block, because now you are providing access perhaps just for that building, and you're making some of your right-of-way improvements, but then if you've got to jump back over to the end of the block, then you're making potentially right-of-way improvements in association with that building, and then if you're further going over to another end of the block, again, you're making improvements in the right-of-way that might not be real sequential. So it can be done, but making those types of improvements in a more disjunct fashion, I think, means that you may not have a real nice, seamless-looking project for some time. So that was the only thing that we were trying to get at there, not to try to belabor that. That is a concern of ours. It is probably a lesser concern in comparison to some of the other issues that we've discussed with you this morning.
Thank you. Also, your staff report referenced whether the consideration of this application would be under the LDC or the LUDRs, and you did reference the city attorney's office. I'd like to hear from the city attorney's office. And then my third question is, before we hear from the city attorney's office, is you had brought up a TIF issue, and I would like to hear from the finance department if someone is here from that. Thank you very much.
Okay.
Right. Good
Morning, John DeClario, City Attorney's Office. With respect to the new land development code and the transitional rules, the new land development code was adopted in August of last year. The transitional rules were somewhat unclear as to amending existing PDPs that were adopted prior to the land development code. The City Attorney's Office feels that the applicant should be entitled to request amendments to his PDP. So we're working on revisions, but we think it's appropriate that the hearing examiner hear this PDP amendment and make a recommendation, and it will eventually go to the City Council for final.
And your recommendation is that that be under the LUDRs, is that correct?
The standards that would be applicable to would currently, since it's unclear in the existing land development code, we would recommend that we use the LUDR standards.
Okay, fine. Thank you very much. I appreciate that. And can we hear from the finance department, please? Thank you. And I believe you were sworn in, sir.
Yes, ma'am. Good morning.
Good morning.
Chris Phillips, Acting Financial Services Director. Previously, the Financial Services Director, Ms. Bateman, ran the numbers for the phasing as it was presented about July or August of 2019. In those numbers, she felt that with the 95% TIF, that the project was viable. We would like the opportunity to run those same numbers with the new phasing to be able to answer any questions on whether or not the project is viable.
At this point, let me make sure I understand what you're saying.
Yes, ma'am.
So at this point, you don't have an answer to the question, how would the TIF be affected, and if so, how would it be affected by the change in the phasing? You need an opportunity to review those.
Correct, yes, ma'am.
Okay, thank you very much. I have no other questions. And I do have one more question for Mr. Struve. Sorry about that. I wrote it down and can't read my own handwriting. It says something. Were the council to deny this this request, are there other options that the city would feel appropriate for a sales center on the property? And I'm talking about not an opinion, but would there be a regulation that would be applicable that would allow a sales center to be located somewhere else on this property?
Yes. Yes, sales centers are allowed. They were allowed under the previous code. They're allowed under the LDC. So
Okay.
a sales center could be, I think there would be subject to some special regulations, because oftentimes when you talk about sales centers, they're in the context of larger residential subdivisions, and oftentimes people are moving mobile homes or something like that, and they have skirting requirements and things of that sort. But certainly a sales center could be placed somewhere else on the site.
So if the building in question were in fact to be demolished by decision of city council, obviously I make a recommendation, there would be something available that could be placed on site on a temporary basis.
Yes, and it's not only allowed, but that's sort of a reasonable expectation. That's common practice for these types of projects, to have
Okay.
a temporary
you.
sales center, not just a temporary sales center, but a temporary construction office if that was needed as well.
I appreciate that. And you could have both of those?
Yes.
Okay, thank you. Is there any other member of the city staff that is prepared to testify on any subject today? Okay, I'm not seeing any rush to the podium, so I'm going to assume that that answer is no. So at this point, I'm going to open public comment. Are there members of the public who wish to provide input or testimony? Seeing none, I'm going to close the public.
May I have the opportunity to respond to a couple of items that were raised?
Let me do public comment first.
Okay.
That's a legal requirement for these types of hearings. As I started to say, are there any members of the public who wish to provide public testimony, comment on this matter? Seeing no rush to the podium on the part of anyone else, I will assume that that answer is no, and I will bring it back to the applicant for any further comments. Thank you.
Thank you, Madam Hearing Examiner. Appreciate it. Again, Annette Barbacha, A&B Planning Consultants. Two items I wanted to address is, based on my discussion with the engineers, they are planning on doing flood proofing in the building. So that was one point raised by Mr. Struve, wanted to address. The other was, when the city was planning to do the improvements on 47th Terrace, it was unclear who would do completion first, the project or the city. And there was a understanding and agreement between the city and the applicant that, because originally they were planning to do pavers, that they would bear the cost of those pavers around the building where the 47th Terrace project is at the time that they do development. The other thing I would say is, when we talk about Class C buildings in the downtown, they're very prevalent. People have been renovating them to a great extent, and I think, as you see with the ice cream shop, they've done their best to beautify that building. It's not going to be the same as the new building, but that's the trend of development in the downtown. There's conversion, then new growth, so this is kind of the new growth stage. And I would say, in terms of the predictability of the project, the city, through the CRA, committing to the TIF for that garage is a key element of this whole project. So if we wanted to go forward, I think the city needs to commit to that 95% TIF. I understand the new financial director has to look over that information, but that was the assessment of Vicki Bateman at the time, that the project in its entirety was a workable project with that 95% eligible TIF. What I did present today, it wasn't part of the original package because it came up as a question after the fact, was that when you look at the income streams from Building B and Building A, they're very similar. So to some extent, the assessment of that building, Building B, should be in a similar vein when you look at the income approach. Thank you.
I do have a couple of questions, if I may. At the time excuse me for pausing a moment. At the time that you did the letter of intent for the prior project back on May 3rd, 2019, I'm assuming that it was on behalf of all members of your of the applicant's team. And I'm reading, it says, on behalf of property owners of Downtown Village Square Project, Downtown Village Square LLC, Downtown Village Square Number 2 LLC, and Red Rock Land Corporation. I know there's been some modification in the applicants as time goes by, which is not uncommon. But I'm assuming that this letter of intent was on behalf of everyone that is referenced in your letter of intent. Is that correct?
That's correct. And unfortunately, it was a missed item. Dan Coomer has been more of a silent partner, even though he did execute the application and was a recipient of all the information that would be presented. So, and it was realized after the fact. And one thing I would say, too, is at the time that we did go for that application, there were a lot of decisions that were being made very close to the deadline of the hearing, and I think if they had more time, maybe they would have realized that they had an issue there, the partners that were presenting in terms of the lease agreement.
All right, and I have two other questions. Do you agree with Mr. Struve's testimony that there would be other options for sales center on the property were the property in question to be demolished?
I think it just, it's an interesting thing when you're requesting public support in a way for this project to make it happen. The whole notion of a CRA is that when you keep adding more costs, if you can use an existing structure, it's going to be much more cost effective than if you have to build a new one. So the feeling of the applicant is, why not use it for a short period of time. And based on the interest that we're getting for Building B, I don't know that that's going to be a long period of time because there seems to be a lot of interested tenants for that building.
Okay, but that really wasn't my question. My question was, do you agree that were the city council to determine that that building needed to be demolished, there would be an alternate place on the property for a sales center to be located?
You know, if you're asking me physically or financially, I guess maybe I was just trying to clarify the question.
Appreciate that.
I mean,
but-
physically, yes, you could do it. Financially, I guess that's another question.
All right, and then my next question is, do you have a perspective on the impact on the TIF by switching the phasing of these buildings?
The feeling is that they're fairly comparable, even though they're different in square footage size. When you look at commercial real estate, it's more of an income stream, not just a sales in terms of a per square foot number. Like you can have a Burger King restaurant that very small building footprint, but generates a lot of income. So, and when you look historically at the numbers in the Cape and what's out there currently, retail and restaurant space generate much more income per square foot than does office.
Okay, and let me see, do you agree with the city attorney's office that the LUDRs are the appropriate regulatory mechanism for consideration of this application?
Yes, we do.
Okay, just wanted to make sure that we were on the same page on that one.
You know,
And do you have a response on the city right-of-way question that I also asked Mr. Struve?
yeah, I don't know that we see it as a right-of-way issue. I think that they feel that they can build the site properly under this phasing scheme. You know, originally when it was proposed back in 2010, we would have had to build around the Fifth Third Bank because they were active at the time. So it wasn't an impediment then. It's not. We don't view it as an impediment now.
Okay, is there anything else you'd like to testify to this morning?
No, the only thing I didn't ask you to recognize me as an expert witness in the beginning, and I hope you do.
I was wondering about that.
Sorry about that.
Can you put on the record the reason for your request? I mean,
Sure.
your qualifications that would lead to that finding.
Sure. I was previously the planning manager in Cape Coral for 3 years. Prior to that, I was the planning director at the New Jersey Pinelands Commission for 3 years. Prior to that, I was with the City of New York in the mayor's office for 6 years. Prior to that, I was with the Department of City Planning for 9 years. I also do commercial real estate. So those are my credentials. I have a master's in urban planning from Stony Brook University.
Thank you. Based upon your recitation of your qualifications, and you have testified as an expert in previous hearing examiner hearings as well, I will recognize you retroactively with regard to all of your testimony today.
Thank you very much.
Okay, thank you very much. Mr. Struve, anything else on your side?
Just a point of clarification in the discussion regarding the TIF. The TIF would actually need to be approved by the CRA Board of Commissioners and not the City Council. So that would require separate action by a different board, just so that is clear. And other than that, I would like to request that my staff report be included as part of my testimony this morning.
Thank you. And if I did state or imply that it was a city council decision, I apologize. I did know it was a CRA board, so thank you.
Well, I think there might have been a couple of people that used that interchangeably, and it's understandable, but I just wanted to make that clarification.
I think it's important to make that clarification, given the importance of the financing here. And I see our city attorney, assistant city attorney, wants to comment as well.
A comment was made earlier. Were you going to add some language regarding the fountain? You said you had some proposed language to suggest regarding the fountain and the
I do. I have
communication.
Excuse me, for the record, Mike Struve. I've got some language drafted, which is a very short sentence in terms of where we believe this should be inserted in Phase 3. As I mentioned earlier, I did give a copy of this to Ms. Barbacha, and she has also reviewed that.
But you're recommending denial of the application, so the proposed language would be for, in the event that city council chooses to.
In the event that city council chooses to approve this amendment with the applicant's request, yes, we would like to see this in the order.
Okay, could you read it into the record? If it's just a short sentence?
Yeah. This would be new number B on Phase 3, which I think appears on page 4 of the draft order. And it simply says, constructing the fountain associated with building A being in quotation marks. And that's it.
Thank you. I appreciate that. And if I need that language, I will take it off of the
All right,
the
thank you.
hearing video. Thank you very much. All right. At this point, having heard from the applicant several times and the staff several times, and having no public comment, I am closing this hearing. It is approximately 10:20 in the morning, and we're moving on to the next item of business. Let's wait for a minute to allow the folks who would like to leave. And if you want to stay, that's perfectly fine. Thank you. Mr. Strebe, I wanted to clarify with you whether we are having hearings on March 10th.
I don't believe we have any cases that will be ready for the 10th, so I would recommend that we cancel that hearing date.
Okay, is there anything advertised for that date?
No, we are not, to my knowledge, we're not preparing anything to be advertised for the 10th.
Oh, okay, all right. Then the next hearing date would be, I think we need to put on the record, would be the 24th? I guess I could look at my calendar here.
Next hearing date would be March the 24th,
All right,
2020.
all right. So the date and time of the next hearing, having heard from staff that we're not moving forward with March 10th, would be Tuesday, March 24th at 9 a.m. here in council chambers. We stand adjourned at 10:22 a.m. Thank you very much, everyone.